Maybe we keep it 5 minutes out. See that call fade, I don't know, before. He's really sitting there. Better than you said this search warrant? Yeah. I don't remember. I just remember the thing about the phone. And like, yeah, he wants to us accusing them. I was snipping about the part of us saying No, we got it on email. Hold on. Yeah. You emailed it to us? Yeah. The special prosecutor down there. Okay, thank you. Is that okay? Okay.
Oh, me too. Sorry. Didn't right in front of the camera. We'll be getting started in a moment. Good afternoon. Everything
So
is
late, Mr. Cosgrove. I'm
yeah,
sorry.
that's okay. The webinar is live. Let you know, FTR, not that you have someone sitting with you, the FTR, the privacy buttons are not working, so
Thank you. Once again, turn your cell phones to put away, thank you.
may I call the case number?
Yes, you may.
I don't want to block. For the record, before the courts, numbers 2 and 3 on today's list, Commonwealth versus Aidan Kearney, 23 CR 313, 24 CR 43. Mr. Kearney is present along with his attorneys, Attorneys Bradl and Mark Bederow. The Commonwealth is represented by Special Assistant District Attorney Robert Cosgrove. The matters are on for various motions. If the parties could please identify themselves for the record.
Commonwealth.
Good afternoon, Your Honor. I'm Robert Cosgrove for the Commonwealth.
Good afternoon, counsel.
Hello, Your Honor. Timothy Bradl on behalf of Aidan Kearney.
Good afternoon.
And for Mr. Kearney, Mark Bederow, B-E-D-E-R-O-W. I've been admitted pro hoc vice for this matter, Your Honor.
All right, good afternoon, sir. All right, a couple of things. I believe counsel was advised, but I just want to say on the record, we are having an FTR issue, so I don't think the white noise on your tables is working. So I just say that to make sure whatever you say to each other is being recorded. So just keep that in mind. If at some point you do need to have a private conversation, let me know when you can step out, but otherwise just be aware of we're being recorded. All right, I know there are a number of matters that we need to address. I'm going to start out with some more administrative issues, which are the motions to impound, which are, so for each one, everything that's filed, there are 2 because there's 2 docket numbers. So the motions to impound are 24, 25, 39, and 40. I did allow those pending any further discussion here in court. So let me start with the Commonwealth. Do you have any objection to the allowance and the continued allowance of those motions?
No, Your Honor.
All right, so those will be continued to be allowed. As far as the motions themselves, where should we start? What would you like to start with?
So, Your Honor, I think we were speaking downstairs for a moment, and the first thing I think logically involves the protective order issues.
Yes.
And to avoid kind of ringing the bell before you make a ruling, I suppose we should do this at sidebar relative to the content of the protective orders and what we're proposing. One of them, we're not far apart on an agreement to memorialize it. The other one, I think we're disparate on the Verizon Records protective order, and the Celebrate Extraction protective order, I think we have it pretty close to agreement. So I don't want to say anything about that in open court.
All right, why don't we approach sidebar?
Thank you.
Thank you. you, everyone, for the patience. All right, other than the issues we addressed at sidebar, what can we do, what else do we have to do to address and help us move forward on these cases?
Your Honor, today I filed a motion to suppress for unreasonable delay, and I would ask for a hearing date on that. Whatever time counsel needs to respond is you know, not a problem from where we sit. The way we see it, Your Honor, that issue needs to be handled before any of the Commonwealth's motions relative to taint teams, and we decline also to accept the offers from the Commonwealth to receive back the discovery. The Commonwealth filed a motion that, I'll give you the title.
Okay, great, thank you.
I think it was in the form of a letter to the court.
Is that the letter? I believe I got a letter this morning.
No, it would be a letter to Judge Callahan.
Okay, I'll look at that.
Judge, I have two actual motions that were filed last time. Is Commonwealth's response to the court's inquiry relative to providing the defendant with copies of seized electronic devices.
That would be it.
That's basically a list of conditions that they want us to comply with that we think are completely beyond the pale, and we decline to accept those conditions. And instead, we filed the motion to suppress for unreasonable delay. It's been over 300 days since these devices were seized, Your Honor. And if you look at the case law, I'm not going to argue it today, Judge, of course, but if you look at the case law, it's well beyond the pale. So our position is that obviates the need for spending any time or taxpayer money on a taint team for a phone that should be returned right away for unreasonable delay.
You want to do the motion to suppress first?
Correct.
What do you say to that?
No.
Okay, and why?
Well, I think Mr. Bradl has it backwards. The normal order of things is that first the search is conducted, and then if evidence is found, the defendant brings the motion to suppress. I'm happy to have the court, or it doesn't really matter whether I'm happy or not. I don't have any choice. I'm willing to have the court, except that the court will hear and act on Mr. Bradl's motion, and I appreciate the offer to set it at a convenient date for myself. But the history of this is, Your Honor, that going back, I think, 1 or 2 hearings ago in front of Judge Callahan, Mr. Bradl raised the issue that the Commonwealth had not moved forward on examination of these digital devices that had been seized by his client. And he pointed out that he had spoken to Mr. Mello sometime earlier, that Mr. Mello had made a proposal as to who would serve as the electronics expert on the taint team, and that he was agreeable with that. And Mr. Bradl argued the law of taint teams. I, for my part, conceded that there had been an inordinate delay. And I went into the extenuating circumstances, which I won't rehearse again today. You've heard some of them at Sidebar.
Yes.
And at that point, since Mr. Bradl had also made a pitch for return of his client's electronic devices immediately, supposedly because they were necessary for his journalistic so-called pursuits, I was asked by Judge Callahan if the Commonwealth would consent to return copies of those devices, and I replied that we would not, but that I was willing to take another look at that issue. He asked me to notify the court after I had taken that second look, so to speak, and I did so on the letter that the motion that Mr. Bradl just referred to. This is the first response to that I've heard from Mr. Bradl. I'm sorry he's not happy with the conditions. But in any case, Judge Callahan also asked that I file, as I said I would, I think by August 18th, I'm not quite sure of the date, a proposal to set up a taint team, and I complied with that order, Your Honor. I may have been a day late, I'm not sure, but not much. And Mr. Bradl has had that motion now for a couple of weeks. I find it ironic, in light of his complaints about delay, that 2 months after he was served with that motion or thereabouts, he now comes into court, files a motion, demands that it be heard before the taint team motion, thereby pushing off the whole process of examination of the devices until after I have time to respond, the court has time to schedule a hearing, we have time to argue it, and the court has time to rule on his motion to suppress. I would suggest to the court that all that's going to do is delay the case unnecessarily. I would ask the court to allow the Commonwealth's motion to establish the taint team, and I think the usual remedy applies. If the court then goes forward and in due course hears Mr. Bradl's motion to dismiss for undue delay and allows that motion, then the usual remedy would apply. The evidence would be suppressed, and Mr. Bradl hasn't lost anything. On the other hand, if the court postpones action on the taint team motion, and I thought we were in agreement that a taint team procedure should be employed. Indeed, the Commonwealth stopped all examination of Mr. Kearney's devices because the defense requested a taint team procedure, and we agreed to it. If we do not go forward on that, every day that we don't go forward is going to add at least 3 months or so, because as Your Honor knows, there's a whole process of examination and opportunity for the defense to object and so forth and so on before the fruits of those search, whatever they may be, are shared with the Commonwealth, and then the Commonwealth designates those pieces of evidence and turns them over to the defense.
Thank you.
Judge, if I may, thank you. I appreciate the Commonwealth's newfound desire to get this done, but it's too late, Your Honor. That's the essence of the motion. This is not an agreement between the parties, Your Honor. This is the government's legal duty under the preventive medicine case to, upon being notified that those materials have privileged items in the phones and computers, it's their legal duty to come forward to the Superior Court. It's their legal duty to include the defense. So in this case, prior Prosecutor Mello completely took a different tack. And the emails are quoted in my motion, Your Honor, that he opposed a taint team. He refused to give the devices back. He refused to give the data back. And he already committed delay beyond what all the case law allows for in terms of unreasonable delay before Attorney Cosgrove even got on the case. All the cases that you'll see cited in my brief in terms of unreasonable delay, they hold it's like 20 days is unreasonable delay, 30, 40, 50 days is unreasonable delay. We're over 300 days here, Your Honor. And the government acknowledged that they needed to do further search warrant work on this case. Mr. Cosgrove acknowledged it himself a few months ago in open court as well. Detective Tully acknowledged it on page 31 of his search warrant ending in number 70. He said, I will file further search warrants. We haven't received anything. And here we are at over 300 days. This case is the most extreme case in the body of unreasonable delay case law. There's no case with more time. Further, Your Honor, the nature of this case is such that Mr. Kearney's been deprived of source material, First Amendment things, attorney-client conversations from several other bits of litigation that he's been involved with his attorneys in those cases. He hasn't been able to get into this stuff. I've given the government notice of this at least 2, if not 3 times, that we need these devices. We can't get the information. The information in these devices concerns source material, and here's the hook, on the very same police officers that took it from him. He's investigating them. And under this case, they took his devices in what can only be a blatant conflict of interest, Your Honor. So they've sat on this stuff for over 300 days. It's coming up on a year now, and they haven't filed any of this stuff. We haven't been served with anything. So I think the Commonwealth, frankly, is happy to just sit on Mr. Kearney's devices, to stifle his further investigation, and that's the real motive for the Commonwealth, just holding on to these devices and not doing anything. So I spoon-fed this right to ADA Mello in October of 2023, giving him the preventive medicine case, and he rebuffed it, and they do that at their own peril. And the time is ticking, and they never did anything, and here we sit. So there's no question, Judge, that it would be an absurd waste of time to set up a taint team and start paying experts to start looking at things, to only then, after the fact, say, oh, this has been gone on for too long, it's an unreasonable delay. There's no reason why the court can't handle that right now. That happens all the time. And so I would ask that the hearing be set up. I don't see how the Commonwealth has any argument whatsoever after 300 days of sitting on my client's devices, refusing to give them back, stifling his journalism, where they could say there's any good reason why they should keep going. So I would ask that we proceed right to this motion to suppress at the earliest possible date, Your Honor. Thank you.
Thank you. All right, so I'm going to take the issue regarding the taint team under advisement. In the meantime, we are going to set a motion to suppress date as well as a date for the motion to disqualify. I'm thinking motion to suppress in November, motion to disqualify in January, but that's just kind of putting it out there. What are everyone's thoughts on those November and then January?
That'd be fine with me, Your Honor.
Attorney Cosgrove?
Well, January is fine with me for the motion to disqualify. I would rather reserve my answer on the applicable date for the motion to suppress. If Your Honor winds up ruling that that is to go forward ahead of consideration of the motion for the taint team, I don't want to put it out to November. I'd rather do it within a couple of weeks. If, on the other hand, Your Honor decides to allow the motion, then I'm in no particular hurry, having already expressed the view that the remedy of suppression is fully available to Mr. Bradl whenever the motion is heard, if it turns out to be allowed.
Is there any reason why we can't sort of do let's just say for sake of argument, I allow the motion for a taint team, and that starts, we could also do a motion to suppress. I'm just trying to move things along a little bit rather than delay.
That's what I would suggest, Your Honor. Okay.
All right. So let's work backwards. January date for the motion to disqualify. When works for Madam Clerk?
We are wide open in January. No Tuesdays.
No Tuesdays. Okay.
How about January 9th, the Thursday?
Yes. Do you anticipate that this would be an evidentiary motion?
It's an interesting question, Judge, whether this is an evidentiary motion, and I've been thinking about that, and right now I would ask for 2 or 3 hours just in case.
Okay, we'll put you on in the morning then.
Right.
Okay, that day will not work. We'll have to do a Monday or Friday morning.
We're talking, forgive my confusion, I'm a little slow in the afternoons. We're talking now the motion to disqualify?
Yes.
All right, I will definitely want to call at least 3 witnesses.
Okay, then we'll just definitely do it 9 o'clock to give ourselves the full day then.
Okay, one
All right,
moment.
so we have a day that works for full day.
So that's January 9th, Your Honor?
Actually, we're going to pick another one to give us more time. That'll give us a full day.
We have to do a Monday or Friday, morning start date. Right out of the bat, January 3rd? Actually, that'll be the last day of the sitting. How about January, 10th?
That's fine.
Sounds fine?
Yeah.
All right, January 10th at 9 a.m. for the motion to disqualify. Right now, I am going to pick a November date. The motion to suppress, counsel, would you anticipate calling witnesses on that or just arguing delay in general? What are your thoughts?
I think, Judge, that'll likely be a non-evidentiary motion.
Okay.
I would ask for maybe 2 hours just in case we do have to call 1 or 2 witnesses.
Okay.
But I don't think so.
Okay.
And I'll certainly advise the court and counsel if I decide that I want to call a witness.
Right.
I would not anticipate calling witnesses for the Commonwealth, but if I decide otherwise, I'll advise both the court and Mr. Bradl and Mr. Bredero.
Thank you very much. Why don't we put that on for 9 o'clock as well, again, just so we're not feeling rushed at 2 to get it in before 4.
Judge, could we do the week of November 18th?
I'm just checking the judge who I anticipate being here, Judge Kropp. I'm just checking his schedule.
We're actually available October 25th, and the next available date is December 2nd.
Can we do December 2nd?
Yes, who would be sitting here on December 2nd? please?
Likely Judge
Sorry.
Kropp. Judge
Yeah.
Kropp would be here.
The short answer is yes, but I do have a trial scheduled that I don't expect to go. I just wanted to put it out there. I think it'll go away, but I do have a trial that day, but I think I can do it.
All right, Attorney
Well,
Kropp, want to say
the
something?
other issue that I would raise in light of my last appearance here is that Judge Krupp is a judge who sat here regularly when I was sitting as a Superior Court judge in Norfolk County. So I don't know if under those circumstances, Mr. Bradl would be inclined to bring another motion to recuse. So I just want to surface that issue now.
Thoughts, Attorney Bradl?
I'd leave that to Judge Krupp, Your Honor.
Okay, so you're not going to make a motion, but if he decides to recuse himself, he can. Okay, why don't we, can I see counsel sidebar about this? Okay, all right, so for scheduling purposes, we're gonna do that December 2nd date with caveat of what we talked about at Sidebar for a motion to suppress, and, January 10th, 2025 at 9 a.m. for disqualification. I will rule on the taint team issue, and as far as that other issue regarding, the first issue we discussed, I did allow the motion to allow Attorney Cosgrove and myself to look at them. Take a look, counsel, and then see if you have any further objection. I think once you look at them, the three of you can probably come to an agreement on that, but if you can't, I will then rule.
Judge, I would like to just leave the building today with the celebrate extraction protective order language worked out.
Okay.
I think my brother's indicated to me that you can do that.
That sounds great. I can, please discuss further. Just, if you come to an agreement, put it on a yellow legal pad that is legible, and then I will sign off on it, would be great. I do believe we have an interested party who is here who may wish to address the court. I'm just checking on that. Is she? Counsel, please.
at 9 a.m. for hearing on the motion to suppress, and January 10th, 2025 at 9 a.m. for the motion for disqualification. Thank you.
Thank you very much, gentlemen. I'll be here for another 45 minutes or so. If you want to get me something, if not, you can get it to me tomorrow. I'll be on trial, but I'll be here, okay? Thank you, everyone.
Thank you, Your Honor.
All rise. Folks, quiet, please, as you exit the courtroom. Thank you.
Madam Clerk, would you mind getting me a copy too? Thanks so much.